Oh, hey, it's Garrett from the Sunshine Reform Ordinance. Please hit the gavel to start the meeting. Okay. Go ahead and do it. Hit the gavel again. It's like the clapper. I'll ask it for TV. Oh.
We're on. Yeah. Good evening and welcome to the regular meeting of the San Francisco Ethics Commission. We'll begin by taking the roll. Commissioner Studley.
Here.
Commissioner Liu.
Here.
Commissioner Hayon.
Here.
Commissioner Rennie.
Present.
All members of the commission being present. Let's start with the agenda. Public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Good evening, David Pilpel. Just wanted to comment and perhaps inquire on the election season that's just concluded. I assume that the staff will be analyzing the effectiveness of the matching or the public finance program and perhaps compiling a report. And I'm just wondering what the thinking is on the timing for that. It's usually a few months down the road, but given the various things that happened this cycle, I think it will be interesting to look at the numbers after the fact, and maybe we can have some discussion at that time about the program and how it worked given what we anticipated about a year ago going into this cycle. I don't know if staff has an indication of when that might be happening.
A few months.
Stay tuned. We'll be here. Thanks.
The next item on the agenda is discussion and possible action on draft regulations of the Ethics Commission's handling of Sunshine Ordinance Task Force complaints. Mr. St. Croix, would you like to introduce this agenda item?
We visited this a number of times, so nobody's any stranger to the subject matter in front of us. The Commission made some progress in combing through input from the Sunshine Ordinance Task Force and then the staff's updated and redirected recommendations. And then once again, after the last time the Commission discussed this, staff has put together sort of a chronology of what's happened so far and tried to distill all of the direction from the Commission into a set of decision points to help us to finish this and then move to getting the regs into effect. So there's 8 decision points in front of you. To go through. The last few are more housekeeping than anything else. But we're ready to answer any questions the Commission has as it goes through these.
My thought was to begin by taking them one decision point at a time. There may be some where we can consolidate, like Mr. St. Croix is saying, towards the end, and we will do so if possible. I second Mr. St. Croix's statements about this process. It has been a long process, but I think a good one, where we've gotten a lot of people weighing in. I think the Commission has heard those voices and tried to incorporate all those points that we think make sense and that will help facilitate the process we are intending to embark upon with respect to these Sunshine Ordinance complaints. The first decision point is regarding the definitions in the regulations. Does anybody have any comment about those? Decision point 1, Chapter 1 of the proposed regulations. I had one question about the use of order of determination. I probably just missed it, but where do we use that term?
Chair Hurd?
Yes.
I don't believe it's used in the regs. I think it's just to kind of identify what would be a referral, what would be coming from the task force.
Okay. Would it be... I mean, we do refer to referral quite often. I guess I'm just wondering whether we should have it if we don't use it, or if we have it, do we want to use it in any place that would add clarification to the...
The order of determination is usually something that accompanies the referral from the task force. It's usually their initial finding that a violation happened. Mm-hmm. So I think staff was just trying to, because there was this two-track process, one that would have a willful aspect to it and one that wouldn't, and they're handled very differently. We were just basically setting out, this is what an order of determination is, and when we get it, this is what the commission's going to treat it as. That's all.
So an order of determination, that's what the actual document is called. Yes. That we would receive.
Correct.
Why do they have an order of determination with respect to willful violations by elected officials or department?
The task force frequently will find that there's been a willful violation of the ordinance and refer that in an order of determination to us.
Okay, but those are the ones that we are going to be looking at de novo.
Correct.
Okay. Any other questions with respect to decision point 1? Public comment.
Good evening, Commissioners. I'm Richard Nee. I'm a member of the Sunshine Ordinance Task Force. I don't know if you have received any communications from the task force about this, specifically from our chair, Kit Grant. But one of the concerns we had at the last task force meeting is that the task force now has 5 new members. There's been a good-sized turnover on the task force. And those members are undergoing a learning curve about this and numerous other issues. We have been at this since April of 2009. That's an awfully long time, and the commission, at the staff and commission level, has exercised a great deal of indulgence and patience, for which we're deeply grateful. At the same time, although I am here not at any authorization from the task force, but I think I do reflect a consensus of the task force when I ask that any final decisions on the regulations be put off further. And I know this is dragged on seemingly interminably, but the consensus on the task force is that we would like to have at least sometime, maybe a month, maybe 2 months, for the new members of the task force to familiarize themselves with this particular issue, and then we could move forward from there.
David Pilpel, also a member of the task force, but speaking as an individual. I'll save my global comments till the end where we consider the ultimate decision of whether to adopt it at this time. But with respect to the definitions, I just wanted to call attention on page 3 of the overall draft. Item Q, referral, and this came up in the last discussion. The supervisor of records under the ordinance only has the limited power to review whether a record is public, and if so, to order the disclosure of the record. The supervisor of records does not have any power under the ordinance to make a referral to this commission or to any other body with respect to such a determination. So I understand that the chair's concern at the last meeting was to just countenance that in the event that it occurred, that a referral from the supervisor of records would be handled in the same manner as a referral from the task force. I just think that it is so unlikely, because it is not provided for in the ordinance, that you should strike or supervisor of records from the definition of referral. So the referral would only mean a document from the task force to the commission finding a violation of the ordinance.
Mr. Pilpel, your point being that the supervisor of records cannot make a referral?
Under the ordinance, correct. The supervisor of records does not have the power to make a referral in the same manner as the task force.
In the same manner of the task?
The task force has the specific power to do so. The supervisor of records does not. The supervisor of records is only a place where a petitioner may seek review of an agency determination not to release a record. There's a two-track process. You can go to the task force, to the supervisor of records, or both, but only the task force has the power to refer under 67.30.
Mr. Chatfield?
So Mr. Pilpel is correct in that there's no specific provision that says the supervisor of record must refer. However, I believe through all the conversations that we had, one concern was, say the supervisor of records makes a determination that they believe there was a willful violation. There isn't anything that would necessarily prohibit them from bringing that forward to here. It was really a cover all bases kind of thing to make sure that we didn't preclude something that may come from another body. It certainly can be stricken, but it really, in the event that it may happen that way, although it hasn't ever, the commission didn't want to foreclose on that option.
Would the question then be whether the definition referral presumes a particular handling, and whether something sent to us, let's not use the technical term referred, sent to us by the superintendent, be handled the same way as a referral from the task force? Are they like things in the same basket here of the definition?
Right now they are, right?
Right.
So the supervisor of records makes the same type of determinations that the task force would. If they were to find that there was a non-willful violation, that a record was public and that it should have been produced, but it wasn't, they're supposed to send that to the Attorney General or the district attorney, just as the task force is supposed to. The task force gets an extra step under 6735D, but I believe the commission looked at that provision to apply broadly to anyone. So potentially the supervisor of records might also say, here, we also find this. You know, they're not mandated to, but they certainly might. And the last conversation that the commission had, I believe it was of sort of leaving the door open to that, so that if we did get a referral from that body, we wouldn't say, well, we just can't do anything.
Okay.
So if I can just clarify, my reading and understanding of the ordinance is perhaps a little different, that the supervisor of records only makes a determination whether a record is public or not whether the conduct of any individual was in violation, or to the extent that it was in violation, whether it was willful, only whether the record is public, and if so, to order that the record be disclosed. The last conversation I had with the individual who currently serves as supervisor of records indicated that that person has never and never intends to make a referral to the commission, believing that it's not within that person's power to do so, just to make the determination of whether a record is public, and just really following very closely to what the powers and duties are of the supervisor of records, which is really extremely limited under the ordinance. I don't want to belabor the point anymore. If you want to leave it, leave it.
Yeah.
I would
Okay.
like to see it stricken. Thanks.
Thank you, Mr. Pilpel. Any further questions or comments on the definitions? Mr. Shen, was there anything you wanted to weigh in on? I think, to me, I'm fine with leaving supervisor of records in there. I understand how people could read the provisions differently, but I support this particular definition. Is there a motion to adopt Chapter 1 of the proposed regulations as reflected in Decision Point 1? Second?
Second.
All in favor?
Aye.
Opposed? Hearing none. Motion passes. Chapter 2 is referrals to the Ethics Commission. Are there any questions or comments from the commissioners regarding Chapter 2?
I guess the only comment I had, and it's not really serious, is that under D, whether 2 and 3 should be reversed. 3 sort of sets out what's to be determined, and then 2 is the vote. And it just seems to me that determination comes before the vote. But I don't feel strongly about it.
I think that's a good point.
Yeah.
I also have a question on that same paragraph, on paragraph 2 under section D. So it refers to findings of fact and conclusions of law. And so I was just wondering what was exactly contemplated by that. Is that something written or just orally when the vote is taken? It's sort of a companion question to Commissioner Rennie's point. And then I see later down in section E, under orders, it says the commission will instruct staff to prepare a written order reflecting the commission's findings. So then I was wondering if what was contemplated was the findings of fact and conclusions of law to be incorporated in that order, which we would instruct based on our vote and our finding verbally. Or is there a more extensive process that's contemplated with respect to preparing findings of fact and conclusions of law? I think we just contemplated the commission doing it verbally during the hearing. Okay.
That was my understanding as well. I mean, certainly if it was a complicated issue where we wanted to make written findings and that the summary order was more involved, I think we could do more, but I think the idea is that we could hopefully make them orally to get to resolution quickly.
Yeah, that sounds good.
In that regard, though, when you go to F, the public announcement, Why is it that the public announcement doesn't need to include findings of, the written findings of fact and conclusions of law?
I think that was just to give flexibility. I mean, I think one thing we're trying to figure out is what form the announcement will take. I mean, if you were just doing a press release, I don't know that we want to be required to if it were a 5-page order, to release the whole thing with the public disclosure. If it made sense to do so, I think we would. But that said, I don't feel strongly if people want to release the whole order. That's fine with me. The order will be publicly available. I think the only question is on a press release or on a list, is it helpful to the public to have all the detail rather than just the headline? Commissioner Sutton?
This may be a technical regulator's question, but unless we need to give ourselves the authority by saying we may include findings of law and fact, is that sentence even necessary? Since without it, I agree that we should commit ourselves, require ourselves to make a public announcement, because these are important. But I wonder whether we need that sentence at all to say that we may but need not include findings of fact.
I think it's a good point.
Does it answer a particular question? It's just.
I think it's a good point. We have had occasions where members of the public have asked for things to be in a certain format and sort of repeatedly demanded that they be in a certain format. And when we're ambiguous or when we're silent, then it leads to confusion.
So the emphasis that I think I hear in your comment is that we need not include the findings of law and fact in this document, is the permission not to do it, not the fact that we may do so when we want to. They might be very cumbersome, and they'll be publicly available in other ways.
To me, that's the benefit of the language.
Okay, so
but
as long as there's
again,
a reason
I mean,
for the sentence. Thanks.
In any other questions or comments from the commissioners on Chapter 2? I had a question about C2. We don't permit, it doesn't appear that we permit email exchange there like we do in the corresponding section for willful violations of department heads, although perhaps I've it's covered in Chapter 4. Okay, it is in 4, but didn't we have something in 3 that provided that briefs could be sent by email?
Yes, it's the last sentence of D2 on page 10.
Is there a reason we didn't include that for a second? Okay. You know, having gone through the process we went through this summer, I found email service to be incredibly helpful and would encourage it. And so if we're going to include it in Chapter 3, I would include it in Chapter 2 as well. public comment on Chapter 2?
Richard Nee, and for record-keeping purposes, I'll spell that Knee. A few things here. First of all, on the question of the press releases, including entire text of orders of determination. In the electronic version of those press releases, there's no reason not to provide an electronic link to the orders. Presumably, they are drafted on computers in Microsoft Word or whatever program, and so the electronic aspect of it is already there in the, with the text. There's no reason not to provide that link. A couple other things. In decision points 2 hyphen, that's Chapter 2, Roman numeral 2, Section D for David, subsection 2, that and Chapter 3, Roman numeral 3, Section B, subsection 2 differ in setting the majority vote threshold determining whether a respondent violated the Sunshine Ordinance. 22D2 states 3 votes would be required to declare that the respondent did not violate the ordinance. 33B declares that 3 votes would be required to declare the respondent did violate the ordinance. Perhaps the difference is intentional, perhaps not, but consistency in language is really always the better option. In decision point 22E and 33C, they do not address what would happen if a respondent failed to comply with an order from the Commission, or if the respondent's employing entity refused to pay a Commission-imposed fine. And by the way, I will add that I do not believe in finding a respondent's employing entity is a good idea. If there is a fine, it should go to the respondent.
David Pilpel again. To the extent that it makes sense, I think Chapters 2 and 3 should have parallel language where there are differences in burdens and whatnot, then they should be different. But otherwise, I agree and feel strongly that they should have exactly the same language covering how things work. I also was going to point out the 3-commissioner vote, but actually from a different perspective. In the event that a commissioner is absent and the commission were to deadlock 2-2, it's not clear what happens then, if a matter would be continued, if there's some presumption that under Chapter 2 that there was a violation, or under Chapter 3 that there wasn't, or just what would happen. I understand that it requires a majority vote of the body to take a substantive action. I'm not questioning that or seeking to do anything different, just to clarify what would happen in, other sorts of events. I have no quarrel with not including the findings in a public announcement. I do agree that to the extent that they exist as a written document, they should be referred to or linked. And again, the public announcement section to F is not exactly the same as 3D at the end. So just trying to create some parallelism there. I'm also a little unclear, and perhaps we could have some discussion on the item that's left in the order, A, to cease and desist the violation and or produce the record. I'm still struggling in my head to find where the commission actually would have the power under the charter or the ordinance to so order. I get that you can make a finding, you can post it on the website, you can send it to whoever you want, you can send warning letters, all of that. It's just the power to order a respondent to cease and desist a violation or produce the record. I'm not sure that I'm finding that explicitly in the ordinance or in the charter, and so I'm just trying to figure out where we grab that power from. We've already eliminated the financial penalty, but I'm just struggling to find that here. Thanks.
There are some good points raised. With respect to the enforcement, I think 67.35D gives us some enforcement authority. Exactly what sort of an enforcement and penalties, I agree, is ambiguous, but I think enforcement means anything. It's got to mean the ability to actually enforce and demand that the records be turned over. With respect to the two different standards for voting, whether it's 3 commissioners vote that there is no violation, or vote that there is a finding of a violation, that has to do with the burden of proof. Because in a show cause hearing, as we've established it, the respondent bears the burden of finding that there is no violation. The commission will be voting on whether he has met that burden of showing that there is no violation, and that's what requires the 3-vote majority. On the flip side, when we're handling something pursuant to Chapter 3, we are voting to determine whether there has been a violation, and so therefore we need a majority vote for that. So that's why, in my understanding, we have those two different standards in terms of whether it's 3 commissioners voting for or 3 commissioners voting against. Were there any comments from the public that caused the commissioners to have additional questions or comments about how things should be adjusted? Is there a motion to adopt decision point 2 subject to the following amendments? 1, to change subsection 2D3 and make that subsection 2D2 and flip it with what currently exists as 2D2. I meant D.
Sorry. And I'm lost. Yep,
This was Commissioner
I'd
Rennie.
read ahead.
Commissioner
Yes.
Rennie's suggestion.
Okay. I was in the next place that this arises. Sorry.
And to add the email communication language to section 2C2. Have I missed other amendments that were proposed? So is there a motion to adopt decision point 2 subject to those changes?
Second.
All in favor? Aye. Opposed? Hearing none, the motion passes. Decision point 3 has to do with Chapter 3. Any comments from the commissioners on decision point 3?
I think we might want to make the same change that Commissioner Rennie suggested earlier in 3B, reversing 2 and 3.
Agreed.
The B2 would become B3, and B3 would become B2.
Right.
Any other issues? I had a couple of questions. Do we have any provision for the situation where something comes to us originally, we dismiss it, and then the same complaint goes to Sunshine and comes through their process?
We have not addressed that.
Okay. Or vice versa. I mean, if it comes through Sunshine and they don't like that, the finding that Sunshine gives, and then they come directly to us. I mean, it would be, I think, helpful to have language that would prevent that, because I don't think we want to handle the same complaint twice, or have it go through both processes if we don't have to. But I mean, are there pitfalls there that I'm missing about that? John?
Just one comment, Chair. I think it would be difficult in the Ethics Commission regulations to address what the task force would do in terms of what it could hear, even if it is something that has been considered by us already. I think that may not be received fairly well.
And we couldn't enforce that anyway.
Right. So at least one of those two eventualities could be, we may not be able to address them in these regulations.
But what we could do is say that we will not take up a referral from the task force that has already been adjudicated pursuant to Chapter 3.
Right. And as a practical matter, if we've already decided that there's nothing there, even if it was filed directly with us, and then they went to the task force and got our referral back to us, even though they have a lesser burden of persuasion, I assume we would come to the same conclusion. So I'm not sure why they would necessarily do that as a practical matter.
Yeah. Okay. Maybe it's not.
I mean,
worth
theoretically,
it.
it's a little easier for them the second time around, but
Yeah.
we'll probably come to the same place.
Any other thoughts? Maybe it's not worth putting in then. I agree. It does seem unlikely. Okay, I had a couple other questions. In A5, I think this is a little inconsistent with A2, but maybe I'm reading it wrong. But I understand that in Chapter 3, we are handling complaints alleging violations of the ordinance by elected officials or department heads, but also those that come directly to us and don't go through the task force. Is that right?
Yes, I think this language was included just to make sure that it was clear that any referral, so from the task force or in the off chance from the supervisor of records, would be handled under Chapter 2, just to make it explicit. So this is not something that would be coming directly to the commission from.
Okay, but a referral where the order of determination is a willful violation of a department head or an elected official would still go under Chapter 3, right?
Correct. And this is just referring to allegations of non-willful.
Okay.
Is that mine?
Mr. Hatfield?
Sorry. So 5, Catherine's right in one aspect that the potential exists. The other part of this was that there was a concern that if something, that staff was not a party in interest, if you will, if it was a referral. So the only time staff would be a party in interest is if we initiated the complaint. Therefore, the executive director wouldn't have any role apart from providing you a legal recommendation on what was presented to him. That's really the intent of this, so that if a referral came, alleging a willful violation against an elected official, staff would, through the executive, or the executive director through staff, would present his legal findings, but would not be an arguing party, if you will, at the hearing.
I see. Okay. Okay, I think I understand. I mean, this is, anything that falls under A2 could not be a referral by definition. Right? Yeah. And, okay. Okay. Third, my last question had to do with the scheduling of the hearing. And I know we talked a lot about this at the last meeting. Having had to work on and as Commissioner Studley knows, having to work on the agenda and figure out how to fit things in, I think it would be helpful to add a caveat about when these things get scheduled. If we could add something like, at the next regular meeting, if practicable, I think that would be helpful. I think it should be our intention to do these as quickly as possible. In the event that we have an unexpectedly large agenda for a particular meeting, we may not be doing the respondent or the complainant any favors by adding them on at the end of a long night. So I think something like that might provide the Commission with necessary flexibility.
I think that flexibility makes sense, given that some of our responsibilities are either seasonal or quite urgent. I would suggest we consider unless impracticable. I think that's a slightly more of a tilt toward including it unless we think it's not possible.
I think that's good.
Okay.
Any objection from the staff? Something like that? Public comment on Chapter 3.
Richard Nee, just very briefly, in 3.2D1, this decision point would set a maximum of 10 pages on executive director reports and recommendations and on complainants and respondents' responses there too. 10 pages can be a lot of things, and I would, in order to speed process, if you will, I would recommend defining whether the contents of the pages should be single or double spaced. I believe that issue came up actually during the Mirkarimi hearing. Also, whether a page with printing on both sides counts as 1 or 2 pages.
David Pilpel, and that's already covered in Chapter 4, Sub 1G, page limitations and format requirements. But it's a good idea. On Chapter 3, I think I had 2 points.
Mr. Pilpel, you don't have to be so snarky about
I'm sorry. I apologize for the snark. Sorry.
But we're impressed.
Okay. All right. Sorry for the snark. The report and recommendation from the director following the investigation, we'll talk about that in a second under Chapter 4 with access to complaints and related documents, but I believe it's the intent that that report and recommendation be the only document that's available relative to the investigation at the time of the hearing. So I think that really needs to be comprehensive, conclusive, whatever attachments are material to the investigation for the review of the commission or the public should be incorporated or referenced, but that's it. I don't think that people should say, okay, well, you're making some reference to some other thing, I'd like that prior to the hearing. It's either whatever's out there needs to be out there for everyone to view and nothing else. So I just want to be clear on the content of that report and recommendation, because I think that in the event that we ever get to this, that may be relevant. Also, I think we need, I've read this several times, but I keep rereading the matters heard under this chapter for both chapters 2 and 3, we may need a separate document that just has a flow chart of some sort that says whether things are in the chapter 2 bucket or the chapter 3 bucket, because I'm sure there will be confusion about whether it's a willful violation, an allegation of a willful violation by a department head who is or isn't an elected official. It gets complicated, and I think people need to know which presumption there is, and therefore which chapter it's under. I'll leave it at that for the moment.
I think,
and I'm sorry, did I apologize for the snark?
You
okay.
did.
All right.
I think the flow chart is a good idea. I don't think it should be in the regs.
No, it
but
need not.
I think for educational purposes for the public, I think it would be good to have something on the website where people could easily figure out, okay, if this happens, then I go down this path.
Right.
Yeah.
And so it's clear both to parties, to everyone. Everybody's got an interest. Yeah, thanks.
Any additional comments from the commissioners based on the public comment?
I do have one question. During public comment, I think it was Mr. Pilpel raised the question of what happens if we deadlock. But the way I'm reading how this is drafted, it would seem to me if there are not 3 votes in favor of then the burden has not been met under whatever is chapter 2 or 3. So I just wanted to clarify whether that's the intent. So it's not really, we're not really going to come up with that scenario of a deadlock. It's just whether there's 3 votes or not in favor of whichever burden, whichever chapter we're under. Is that the intent?
Yes, it was the intent. I don't know if you-
Yeah, so just one other thing. If there is hypothetically some meeting in which there are only 4 members of the commission and it's 2-2, say, there could also, you could still form a majority, continue the matter until there is a meeting where there are 5 people.
Okay.
So even if there is a single meeting where there is a deadlock, there are still options available to the commission to sort of dispose of it in a more satisfactory manner.
Okay, thank you.
Can I just follow up on that?
Briefly.
Okay. In the event that that were to occur and there were only 4 members and you held the full hearing and deadlocked and then continued the matter for a decision, I think you should have some provision in here that an absent commissioner must view the proceedings and certify on the record that they have viewed the proceedings, are familiar with the materials and evidence, and are prepared to take up the matter. I think to just assume that all of that would happen in the absence of a reg requiring it is potentially problematic. But I can see that scenario playing out, and that may be preferable. I mean, I want to preserve the commission's options, but I can see that playing out rather than saying everybody's here, let's go with the hearing. Oh, but one of our members took ill this afternoon. Why don't we just continue the entire hearing? I mean, you want to have options either way. Thanks.
I think that's a reasonable suggestion unless our standing rules, in a sense, already have those kinds of requirements for being able to, as a standard for a commissioner being able to participate in something for which they were not at the meeting. Does anybody know if we have such kind of standard provisions?
Yeah, I would just say, at least when the city attorney's office is involved in situations like that, where there is a proceeding in which not all the members of the commission have been in attendance, and when we've consistently advised that if that person is going to join later in a subsequent hearing, that they do review the record. I'm not sure if that's been written down anywhere per se, but I would just say that, obviously in the regulations we're trying to cover a lot of ground, but we may not necessarily cover every single thing that's going to come up at the end of the day. Don't know how likely they'll be, but that's what we generally advise boards and commissions that have hearings like this.
We've used the provision in the past.
Mm-hmm.
And I'm sure staff would concur with that recommendation as well.
But I don't recall if it was mandated or we did it out of a sense of doing things correctly.
Yeah, we have made representations on the had made them make representations on the record.
Was it? The other regs? Oh, the other regs, okay.
So we do have them in the regs?
In our current enforcement regs, there is a sentence regarding certification for the commissioners on that, and we could just use the same language. It's actually on page 14 of attachment B, the last sentence.
Good find.
Where?
We could add that.
The last sentence of section B on page 14.
Okay, I'm sorry.
Yeah, I think that would be helpful, and I know we have utilized that because I was one of the people who had to certify.
I think we should add that. That would go. I guess we'd want to add that to chapter 2 as well, wouldn't we?
Should we put it in chapter 4?
Put it in chapter 4. Any views from the commissioners on whether to put that in chapter 4, and we can discuss it in a second when we move to chapter 4. Okay, then I think the changes that are being proposed for section 3 are to flip 3B2 and 3, and to add unless impracticable after next regular meeting in 1B1. Is there a motion to adopt decision point 3 with those changes? We took public comment on that section. Is there a second?
Second.
All in favor?
Aye.
Aye. Opposed? Okay, this is chapter 4. Aside from adding the language from page 14 of attachment B, any other comments from the commissioners on decision point 4?
I have a question.
Okay.
Taking that language from page 14 of attachment B, that read in its entirety, that section presumes that there may be commissioners who have missed the hearings. So if the hearing only takes 1 day and all of the commissioners are here, I don't think you need to make that affirmation because you were here, with witnesses. So you can put it in the way it is and it doesn't really do any harm. You just have to make that affirmation even though you were here for the whole hearing. You could put a header in it that says, any commission not present for the entirety of the proceedings shall, and then put the language in there. I'm not trying to complicate things. It just adds a level of procedure that you don't necessarily need to go through if everyone's here. But it won't take that long for everyone to do it.
I think it's a good point. Well, yeah. Certainly don't want to add additional unnecessary procedural requirements. Where would we add that?
I would take just the last sentence of the paragraph that states each commissioner who participates.
Now you're looking at attachment B.
Right. Page 14, section B, the last sentence. So that would read, each commissioner who participates in the decision, comma, but has not attended the entirety of the hearings, comma, shall certify on the record that he or she personally heard the testimony, etc.
Okay, I think that's good. And where would we put it?
Section 4, I think I would just add at the end,
Make it J.
yeah. Just add a new section, make it J. Then you'd have to renumber all the other sections. There's a particular need for chronology here.
Mr. Chatfield or Ms. Argumento, any? Okay. Okay. Any objections from the commissioners on that? Any other comments on decision point 4?
Just a comment on, maybe unnecessary, but under the ex parte communications, it does not preclude communications between commissioners. I know that there are other provisions that may take care of that, but I'm just curious, is it intended that one commissioner could talk to another in advance of the hearing concerning the subject matter when the commissioner can't talk to a staff person, can't talk to an executive director? I'm just curious.
There's nothing in law that would preclude you from speaking to one other commissioner. Obviously beyond that is a seriatim problem. But I don't anticipate, this is a limitation you would be placing on yourselves, a problem with adding commissioners into that mix of non-communicants. When that word popped into my head, I swore I wouldn't get it out, but I did.
I don't feel strongly about it. If the commission wants to prevent commissioners from talking about it amongst themselves, that doesn't bother me. I don't know that it's necessary, but I wouldn't object.
I'm just looking at it more from, and be interested what the public comment might be, whether or not they think that the ex parte communication should include no communication between the commissioners, even between one commissioner and another, prior to the hearing. Being that we're excluding almost everybody else.
Right, although we're excluding anyone who would come before us and would be presenting evidence or making argument.
The only circumstances.
Or referring to us.
Excuse me, sorry. The only circumstance I could see would be, and you and Commissioner Studley would know better, whether the chair and vice chair need to talk prior to a hearing about the running of the whatever matter is going to come before the commission, and whether we should whether that would be a limitation on the chair and vice chair, just talking about how to conduct the matter going forward.
That's
So that would be my only
be-
hesitation.
I wonder if that's taken care of by the fact that this relates to the merits of the complaint and excludes scheduling.
Right, so perhaps,
Maybe that's
yeah,
anticipated.
yeah.
Okay.
this is very fussy, I hate editing as a group, but except for communications generally committed between a court and a party, communications are not typically committed. It's an odd phrasing.
Conducted?
That would be better. It's the sort of thing we count on Mr. Rennie for.
Any other proposed changes to Chapter 4? Public comment.
I'm still Richard Nee. In the previous draft of the decision points, there was a provision declaring that the Commission would not be required to televise portions of its meetings held in closed sessions or otherwise required to be confidential. Unless it's escaped my eyeballs, the current draft does not contain that language, and I would like to see the subject reintroduced, but I suggest that the Commission require audio and or video recordings of all such sessions, with the recordings to be made available for in-camera review in case questions arise as to whether any illegally confidential actions or discussions have taken place during those closed sessions.
And I'm still David Pilpel, and I'm generally committed, or I probably should be. Let me go to item B, access to complaints and related documents and deliberations. Without complicating this section unnecessarily, we've seen complaints about investigative files. I don't know how explicit this particular document should be about complaints, files, and related documents. I just don't want anyone to interpret any more or less from this language than is appropriate. I'm not sure that I'm prepared to think through whether an investigation under these regs is the same as an investigation under C 3.699-13, whether it's an investigative file as a law enforcement agency, how it deals with Rivera. All of those issues, I suspect if we ever have a referral or have an investigation and generate these files, somebody's going to say, let me see them, and then we're going to go back and forth about whether it is or isn't. I'm just trying to anticipate some of that now and have some more language in here or some different language than shall be disclosed as necessary or as required under CPRA or Sunshine, which isn't necessarily the most helpful. I mean, it's true, but what does that mean?
So what, you would propose to strike it entirely?
I'm struggling, and I'm not quite sure what the best answer is, frankly. I'm expressing a concern about it, and I suspect we're all smart people in the room, and we all probably have different views about the matter. But I think we can all see that there's something. I don't know. The question about ex parte communications, I was also looking at the existing regs, page 15 of attachment B, miscellaneous provision sub A about ex parte. I like that language generally. I think that was adapted here in a way that pretty much makes sense. I just don't think, I think it makes sense to limit ex parte communications between parties and representatives of the complainant and respondent and members of the commission, but beyond that, I would be careful about how much you limit it. If a member of the public comes up to you on the street and says, hey, I know you're on the commission, that allegation seems silly, or that person, I think, really did something wrong, you should do something about it. I'm not sure that you should be any more limited in engaging that discussion than you are under other regs regarding how other complaints are handled. Even if these are a more public, I mean, this is certainly a more publicly known complaint than a complaint handled elsewhere. But if someone knows about it and someone wants to engage and they're not representing a party, and we're not barring that communication with respect to a different type of complaint, I don't know why you would have a higher standard here. Maybe it was just the language, any member of the public. But I guess that, too, is subject to interpretation if it's any member of the public who is communicating on behalf of one of the parties. If they're not, then maybe it's okay. All right. More in a minute. Thanks.
Yeah. Okay, so what does the commission think about the ex parte language? Was there a reason we didn't follow the language from the regs?
There's no specific reason why we didn't adopt that. We definitely wanted to make it clear who the commission shouldn't be talking to, and we just presumed that you would follow the rules that you can't speak to more than one of you, as you know, as a normal matter of course. So we didn't specifically identify that commissioners couldn't speak to each other. There may be a time when it's necessary, possibly. So if there were three of you were together, that'd be a problem on a whole different level. So.
I think I would be in favor of leaving it as is and changing committed to conducted. But like I said, I don't feel that strongly if others on the commission do. Okay, so the two changes we've talked about for Section 4, Decision Point 4, is changing committed to conducted in 1A and adding Section J, which will be similar to the last sentence of Section B on page 14 of the existing regs, with the addition of
Each commissioner who participates in the decision, comma, but who has not attended the hearing in its entirety, comma, shall certify. Got that? Garrett? Okay.
Is there a motion to adopt Decision Point 4 as amended? All in favor?
Aye.
Aye. Opposed? Okay, the motion passes. But, you know, I had one other question about Decision Point 4. I don't think it'll change the vote. Can you give me an example of a complaint that would apply under I?
Someone could allege that a city official violated the conflict of interest rules and was at the same time not provided a public document in support of or related to that. It could possibly be withheld by the same person. Mm-hmm. We're just trying to allow for the, if it were to occur.
Okay. Okay. So I think that the decision points 5, 6, and 7 can be handled together. I think they're pretty minor. Does anyone on the commission disagree with handling 5, 6, and 7 as one decision point? Any comments or questions with respect to the proposed edits to the regs as discussed in 5, 6, and 7? Public comment?
David Pilpel. A couple of things. On the agenda for tonight's meeting is discussion possible action on draft regs governing the handling of complaints related to alleged violations and referrals from the task force. I'm not sure if and now Andrew's out of the room, I'm not sure if within that scope you could actually act to amend the regs for investigation and enforcement proceedings. It may be a close call, but it may depend on whether you intend to take final action tonight or not. I don't have any particular quarrel with the proposed edits to the general regs. If I could for a moment on your last comment on sub I in section 4, chapter 4. In the event that there is a complaint that alleges both a sunshine violation and other improper governmental activities of whatever sort, I would hope that the staff-initiated complaint pursuant to the last section doesn't reveal any more or less than necessary for the processing of the sunshine-related complaint, because the regular complaint wouldn't be disclosed under current provisions in the event that it's dismissed or not, doesn't get to a probable cause report, et cetera. So I'm not sure that you want to reveal any more than you would otherwise just because someone added a sunshine allegation to a complaint.
Where do we discuss disclosing the contents of the investigative?
It doesn't, but where it says staff shall initiate a complaint of the alleged violation, so then staff would be initiating the complaint, but they would have to import the allegation, facts, whatever, from the complaint presumably filed by another, unless the original complaint was staff initiated. But if someone hypothetically complained against a department head and said they absconded with funds or did something inappropriate and, by the way, didn't give me records that I was entitled to, you would, through this reg, bifurcate the complaint, handle the one as improper governmental activities and the other part of it as a sunshine violation. But I just want to be sure that people have enough information to go on the sunshine complaint, but you wouldn't necessarily reveal who the underlying complainant was. You would necessarily have to reveal who the respondent is.
It's an interesting point.
Sorry, yeah.
I wonder what the staff thinks on that, because the staff can initiate a complaint either on its own awareness, right? Or can say, we heard about it from X, but we're going to erase X and just
If something is,
pursue a complaint.
sorry, I didn't interrupt you. First of all, we're bound by the confidentiality provisions of the other enforcement regulations, so we would be under we would be very careful to make sure nothing that would be considered confidential was disclosed. We also would have the opportunity to file on behalf of somebody or staff initiated, then it's staff versus public official X. So the original complainant could be hidden or masked in that sense.
I have no quarrel with that. I just wanted to anticipate that that's how that might play out. And then my last comment, I'm sorry, I'm also going back to the Chapter 2, Chapter 3 issue for a second on the 2 versus 3 votes. I have no problem with the Chapter 3 presumption that if you don't have 3 votes that there's no violation. But under Chapter 2, if there aren't 3 votes to not find a violation, then it sort of suggests that there was a violation. And that, from my perspective, is potentially problematic. I don't want there to be that inference that just because there weren't sufficient votes to find no violation, that therefore there was or might have been. I mean, it kind of leaves a cloud there. So that's causing me some heartburn or something. Thanks.
Okay, Mr. Shen, first question for you is, when you're out of the room, of course, that's when your name is invoked. There was a question raised as to whether we can amend the regs given the agenda. Do you have an opinion on that?
You mean just it's a noticing question? Yeah, we can change the regs, and we do change regs and ordinances and approve them at the same meeting.
Right, but is the notice in the agenda sufficient to do so?
Wait, what? Wait, I'm sorry, we want to change our regular enforcement regulations as well?
I think we got our answer.
Decision points 5, 6, and 7.
But sorry, if we could have just
Sure,
a second.
take your time, please.
Because this agenda item only addresses to these, right?
I see.
Right. 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 Because the agenda item only refers to those regulations. The Sunshine regulations, yeah. Why did I approve that? I think the better practice would be to make that change at a later meeting. Because the agenda item, as I read it, refers to the regulations concerning sunshine complaints.
Okay. Let's defer 5 through 7 then, unless the commission, I think these are pretty straightforward changes, but want to make sure we're properly noticed. Any objections from the commissioners? The other issue that I think may be worth discussing is this idea that if, under Chapter 2, if we don't have a majority voting to find no violation, are we comfortable with two or fewer are we comfortable with a situation where we wouldn't have a majority one way or the other?
Could you just remind us, sort of for the record and the discussion, how many commissioners it takes to hold a meeting in the first place? It's not that there could be one person or two people here.
There have to be 3. I mean, sometimes 4, depending on the issue, but for this, I think we could do it with 3. But you would be in the situation where potentially if you had 3 members of the commission hearing the issue, that you wouldn't get a majority either way, thus finding a violation with only even one commissioner supporting the finding of the violation, which is somewhat troubling. I don't know if staff has
Gives you a
views on
meaning
that.
to presumption, doesn't it?
All right, before I hear from you, Mr. Pilpel.
Yeah.
So we could put a provision in here that says 5 members must be here in order to have a hearing to ensure that, that situation doesn't occur. Even with 4 members, you could still have a 3-1 vote, and that would be perfectly fine. You could have a 3-0 vote with just 3 people sitting here, and that would be perfectly fine too. But if you want to ensure that a party coming to you has the full access to the commission rather than 4 or 3, then we could certainly write something in here saying no hearing will be held unless, all 5 commissioners will be there, although there could be potential issues if someone's suddenly ill or there's an emergency, then we have to suddenly cancel everything.
Mm-hmm.
You could flip it. You could make it that you need 3 votes to find the respondent has committed a violation and make the burden easier on the respondent.
The burden would remain the same on the respondent. Mr. Chatfield?
Hopefully I'll make it easier. So the reason the show cause hearing was developed was because there was a concern that something coming from the task force, they've already made a decision. So the commission wanted to ensure that that commission or that decision was sort of coming in upheld. So the presumption is a violation has occurred when they come here. So the respondent has to show why the task force was incorrect in making that decision for you to move on the show cause part, not chapter 3. So I don't know if that would necessarily, but that would wind up changing the entire show cause procedure probably. We're basically taking the presumption of a violation occurred out if that was to happen.
Yeah, I was trying to think out loud as to whether we could maintain that presumption while switching around the vote, but maybe not.
Could we simply say at a meeting attended by 4 or more commissioners? A meeting or meetings,
You still
with
run
the
the risk.
participation of 4 or more commissioners?
You still run the risk of a 2-2.
Could I add one more thing? When we have hearings, we always endeavor to have all 5 commissioners here. So it's been very rare that hasn't happened. I think it's only happened once. And that was not for a part of a hearing, but to make some post-hearing decisions.
Well, that's not true. I mean, we've had plenty of meetings where a commissioner has had an excused absence for one reason
I
or
don't
the
think
other.
we've ever had a hearing.
Well, right, but this would be at a regular meeting.
Okay. So then I think we would approach this that the next practicable meeting would be one that all 5 commissioners are in attendance. Just make that a practice. If it doesn't, if you want to memorialize it now, you can, but we may not always need to do it. But if we just sort of institute it as customarily how we handle things, it leaves us with some flexibility for future scheduling.
In the event of a 4-person commission meeting, I'm just trying to play this out.
Yep.
And a 2-2 vote, there seem to be 2 options. One is, since there is a presumption and a prior finding, the 2-2 leaves that, i.e., the Sunshine Task Force finding remains, it goes into effect, becomes our finding because we were split 2-2, i.e., don't have a 3-person vote. Or, as we discussed earlier, could be carried forward to the subsequent meeting. If the commissioners at the 2-2 say that was so complicated, hard fought, sincere, we really ought to, this is one that we really ought to bring forward to the next meeting and allow the 5th commissioner to the possibility of either, of doing this by a 3. 3-2 vote, whichever way that commissioner should go. But I think we have those same options, and the 4-person meeting could yield a 3-1 or 4-0 result without binding us to always have to have 5 for these. We don't know how numerous, how frequent an occurrence this might be. I just hate to, I respect the practice, and I think the executive director makes a good point that may be the practice to try to have 5 when we have hearings, but it's a high standard if it is something that since part of what we want to do is be able to bring these forward and act on them in a timely, responsive way, I'm just trying to figure out how to make solid decisions, but without being unrealistic about how often we can get 5.
I think that's a good compromise. Mr. St. Croix, did you have something to add?
No, I was just thinking the circumstances are going to be limited anyway. If there's 4 people and the vote is 3-1 against the respondent, the result's not going to change even if the other commissioner was there. And if there's 3 commissioners and the vote is 3-0, the addition of 2 commissioners wouldn't change the outcome.
Right. It's the situation where it's 2-1, and the 1, particularly in a situation where the 1 is the vote to find a violation, and you've basically found a violation based on 1 vote.
Yeah. So in a situation where it's 2-1 or 2-2, the outcome could change. In which case, that's when you would not postpone, but continue the hearing to the next session.
I like this idea of requiring 4. We require it for some things already, and I think this is something where it would be helpful to.
Are you saying a vote of 4 or 4 people at the meeting?
4 people in attendance.
Right, yeah, that's
what I was thinking. Is that, we got to lean on the staff here a bit. We don't want to do something that's
the simplest thing to do, because you can just add a sentence under the scheduling or show cause hearing that if 4 commissioners aren't in attendance when a hearing's on the agenda, it has to be held over to the next meeting, that there are 4 commissioners present.
that sound
It would only take 1 sentence to achieve that.
okay? And is that something we'd want for Chapter 3 as well? I know we have a different burden and presumption, but it strikes me as a little odd that there could be a perception that we're treating one more seriously than the other based on our requirement of how many commissioners need to attend.
I think it would be fair to add to both.
Okay. And if that's the case, can it just be added to Section 4 rather than being added to both 2 and 3?
We can do that.
Okay. Any objections from the commissioners on that? Do we need to re-vote and take public comment again on it?
Yeah.
Okay. Let's take public comment on it.
So,
Mr. Telltale.
sure. So I think where we're going with this is on Chapter 4.1E2, the commissioner or the commission chairperson may reschedule a hearing at their discretion for good cause. That might read, may continue or reschedule a hearing at their discretion for good cause. Good cause may include absence of 1 or more commissioners.
I think that's a little too discretionary for what we're talking about.
Okay. Anyway,
But it could probably go there.
Somewhere in that
Yeah.
range. And I think on the Chapter 2 question, I would probably not change the burden. I think the standard of proof and burden in 2B kind of makes sense. That was what the whole basis of the Chapter 2 versus 3 thing was. But I think I would be better with 3 positive votes needed to make a finding that there was a violation. So even if it requires 3 votes to find a violation, you can still hold the person to the burden. If they didn't meet their burden, then you go the other way. Although it does play out in the same ways that we've talked about. Yeah. I also would not substitute, there was a suggestion at one point to substitute the finding of the task force for the commission in the event that the commission doesn't overturn the task force. I think that the task force and the commission really stand separately, and I would not suggest that you take the task force recommendation on its own. I think you can choose to, but I don't think that there should be some reg that provides, in the absence of a commission decision to the contrary, the task force decision stands. I think that there really are different powers and duties, and I wouldn't want to conflate those. I think I've said enough for the moment. Thanks.
Attorney.
Respectfully, I disagree with Member Pilpel on the question of burden of proof with respect to Chapter 2. The fact that a matter has been referred from the task force means that the task force has found a violation, perhaps a willful one. And I think that the burden of proof definitely should rest with the respondent in that case. As a matter of fact, I think that if you recall, when the task force refers matters to your august body, we're not looking for re-adjudication. Now, perhaps the new members of the task force would find differently. Again, we have 5 new members. So it's possible that consensus would change. But when this matter has come before you, before us, with the task force previously constituted, the consensus, and a very strong consensus of the task force, has been, we're not sending matters to you for re-adjudication. We're sending them for enforcement of our orders of determination.
I mean, I agree that the point of this was to provide some deference to the task force decision, and I for one, am comfortable with the possibility that on a 2-2 vote, a task force finding would be upheld if the commission felt that was, the members that were present felt that was appropriate. If they felt like they wanted a full 5-member commission to decide it, then they can so find and continue the hearing. But I'm comfortable with the arrangement that we've just discussed. Any objections from the commissioners? So we would add a sentence perhaps to section 1E2, that the commission or the commission chair shall reschedule the hearing if at least 4 members cannot attend. I'm sure there is a better way to say that, but that idea be included therein.
Let me read something for you. Edit.
The only concern I have when you use the language shall, that's correct. If the 5th member of the commission, 5th commissioner, for one reason or another can't be present, but he or she feels strongly that they want to participate, it seems to me you should have discretion. If that commissioner said to you, I really wish you would schedule it when I can be there. Mm-hmm. But the way you've worded it, it wouldn't be.
Why
Because
not?
if there are 4 there, it says you shall set it.
Oh, I'm sorry. I meant to suggest that they shall continue it if there aren't at least 4 there, but leave in this sentence about rescheduling for good cause, which could be the. But if you have better language, I'm all ears. I made it up on the spot.
No, I just want to leave some discretion in the chair as to whether or not it has to schedule it if there are 4 going to be present.
Yeah, I think that is important. Do we need actual precise language to re-vote on?
Can I read this?
Sure. Oh, sorry. Go ahead.
At any time a hearing is placed on the agenda, 4 or more commissioners must be in attendance. Otherwise, the hearing must be continued to the next meeting. Excuse me, the hearing shall be continued to the next meeting.
And that's just in addition to what is already
Correct. We're not
there.
taking anything out.
Does that sound reasonable?
Yes.
Okay. Is there a motion to amend our finding with respect to decision point 4 to add the sentence that Mr. St. Croix just read into the record?
So move.
Second?
Second.
All in favor?
Aye.
Aye. Opposed? Hearing none. Let's move on to decision point 8. Shall the commission approve the regulations to handle violations in their entirety as proposed, as amended by the commission at this meeting? I am certainly sensitive, Mr. Nee, to your concern that there are new task force members. However, I think, for me at least, given how long this process has gone and you know, the great deal of input we have gotten from you and former members of the task force, I do think we need to move forward here. Certainly, we're not closed to improvements to these regulations as we go forward and actually engage in some of these hearings, but I think it is important that we close the loop on this. Any other comments from the commissioners with respect to decision point 8?
I agree with Commissioner Herr, but I also do want to acknowledge that it's a very important point. And for me, the fact that we can take insights from the task force and its new membership and improve this or improve it in light of our experience is telling. It has been a long time, and it's tempting to say what's another month or two, but the challenge of even getting us together or the task force together for additional meetings has proven so cumbersome that I'm, although usually a great optimist, not optimistic that we could do it that quickly and then time would move on. I also am remembering the encouragement that we've received at a number of meetings to actually be able to bring forward some of these matters. And for me, that weighs heavily in the balance as well, to be able to actually move them and pay them the respect that they deserve and bring them onto our docket at our meetings. I wonder, however, whether we could do something that would, for example, in addition to whatever the task force decides to do to convey their thoughts to us, whether there's something we could do that would remind us, for example, at a 6-month point to ask if they have any comments on this, or after we've done a certain number of these hearings, to just make sure that we explicitly invite their observations on the rules as they're being applied, or in some other fashion to acknowledge that we, are open to their thoughts. Maybe a year is a better time, given that we want to have some experience with it.
Mr. St. Croix, do you have any thoughts on that?
No, I mean, everything we do is always a work in progress, and I'm sure after we conduct some of the hearings under this procedure, not after even, but during, we'll get feedback on them. Mm-hmm. So, we'll pay close attention to how they go, and always we intend good outcomes and hope we get them. We'll see what, how everything constructively works, and then go from there.
Comments from the commissioners on that? So I think that's reasonable, and maybe the commission staff could put on the list that we should revisit this in a year or so and seek comment not just from the task force, but from other interested entities about how this is playing out. Public comment on agenda item 8. Decision point 8.
Just a quick question. What you're actually voting on here is the regulations as they appear in attachment A, is that correct?
No.
Or just the decision points drafted on November 16th?
These are the decision points that are that we've just been discussing.
Okay.
We're just adopting them.
Okay, just
as a
wanted
whole.
to clarify that. And again, I absolutely understand your position that this has been a long, drawn-out process. Again, I applaud the patience that you've exhibited in listening to the task force, listening to members of the public. We move forward from here.
Thank you for saying that. Is there a motion to adopt decision point 8, the San Francisco Sunshine Ordinance regulations as amended by the commission at this meeting?
So move.
Second.
All in favor?
Aye.
Opposed? Hearing none, it passes. And once again, a great deal of thanks to the public, the task force, and a great deal of thanks to the staff for handling this. It's been a difficult process. I know firsthand how much work you all have put into it, and you can tell how long it's been when you're constantly having to remind us what we had talked about and decided at previous meetings, which I'm sure is frustrating for you, but appreciated by us. So thank you for your hard work. The next item on the agenda is discussion and possible action regarding amendments to CFRO. First, let me check with the commissioners. Are we okay going forward? Does anybody need a short break?
Fine.
Fine.
Okay. Mr. St. Croix, would you like to introduce this agenda item?
So during the summer days of the mayoral campaign, the most recent mayoral campaign, we had issues that presented themselves to us that were new to San Francisco, in that there were let me take that word back. There were committees organized to draft Ed Lee to run for mayor. He was at the time considered to be a caretaker who was filled to fill a vacancy until the next election can be held. There were at least 3 such committees, I think maybe 4, and some of them raised good sums of money. And my concern was that they were functioning as campaigns without actually being campaigns. The commission decided that they weren't campaigns under current law, but I think the commission agreed that the raising and spending of that size of money was not designed by the voters to be something that went unregulated. So the commission directed the staff to put together some provisions that would, as I said, regulate committees that are designed to draft a specific candidate, particularly those that raise tangible sums of money. And the reason for this is that a citywide campaign aimed at a single person still reaches people citywide and could conceivably impact their decisions at the polling place based on the fact that you get someone to run for office by extolling their virtues. So essentially these relatively simple to follow will treat, under our law, such committees, as primarily formed campaigns, and therefore they will be more than free to conduct the activities that they have, as we've seen in this particular incident, but they will have to report their activities to the voters.
Thank you, Mr. St. Croix. The memo is divided into 2 decision points. I think we'll take them one at a time. Do the commissioners have any questions or comments with respect to decision point 1? I have a question, and it has to do with our definition of support. I have some concern that it's maybe a little too restrictive, because I could imagine someone simply spending money to advocate that someone be elected without, quote-unquote, encouraging or urging them to declare. I mean, certainly in the run-and-run instance, there was that case where they were trying to encourage him to declare. But what if it had just been elect Ed Lee for mayor? Would that fall within this definition?
I would say it would, because if you've identified Ed, if Ed is not a candidate,
right?
And someone makes an effort, an expenditure or other method to support that person, when they're not a candidate, it should, I think the average layman would say, well, that's an inducement to run.
But why are we setting ourselves up for that ambiguity? I mean, why do we even need to define support?
If I may, I don't know that we necessarily need to define support, but the definition of a draft committee really is a committee that spends or raises funds of $1,000 or more. So if it is just somebody who urges somebody to run without raising funds, no money is involved.
Right.
That would not be a committee.
Right. Agree. But what if they're not, quote unquote, encouraging them to run? I mean, we're still trying to capture anyone who's spending money to support the election of someone who's not a declared candidate, regardless of whether they're saying, hey, Mr. Thompson, we really want you to declare as a candidate, versus saying, vote for Mr. Thompson, he'd be the best mayor for San Francisco.
So what you're saying, if I understand it, vote for Mr. Thompson, he'll be the best person for San Francisco. That's really getting him on the ballot, or getting him nominated, or getting him certified for nomination where he has not taken any action to become a candidate?
Right, exactly. So I think we want to cover that situation, because we want that draft committee to be covered by this.
Right, and I think as the executive director says, this law will cover that situation.
Okay.
Where you have an individual who has not declared as a candidate, who has not given permission for anybody to raise funds or expend monies on his or her behalf, who has not given permission to be on the ballot. This will cover those committees that raise funds or spend money, spend at least $1,000, or raise at least $1,000 to encourage that person to be the next mayor or the next member of the Board of Supervisors.
I guess I've got to say, I don't see what ambiguity is being created by the definition of support, because your example would seem to clearly be a case where somebody was encouraging somebody to run.
But why? I mean, if I just say vote for Ed Lee for mayor, but
he can't vote for him unless he's a candidate.
You could write him in.
Pardon me?
You could write him in.
Yeah, but even to be a writing candidate, and the city attorney can, the deputy can correct me if I'm wrong, to be a writing candidate, you have to, I think you have to have an approval prior to do that, right?
Yeah, so effectively, to take office or to actually be elected to something, at some point you're going to have to declare as a candidate. So even if there is someone starts sticking in yard signs, say, Bob Thompson for mayor, and for Bob Thompson to actually appear on the ballot and to be elected, at some point, Mr. Thompson would need to declare. So
Okay,
while that's
but
not necessarily spelled out on the yard sign,
But this is not about whether they can actually achieve the elected office. We're aiming at people who are spending money in support of a candidate, in support of someone who's not a candidate for elective office, and we want to close that loophole. So I guess I don't see the advantage of limiting it to people who are encouraging or urging. I mean, why not just leave A1 as is? I mean, I have another slight amendment to it, but what are we worried about that required us to define what support means?
No, and I think that's a fair point. So I think what you're generally saying is that if we define support, we're possibly excluding things that aren't captured in the definition.
Right.
I think that's a very fair point. I would also just point out subsection 4 does allow the Ethics Commission to propose regulations, and I think that the reason that we put that in there is that we know that to the extent there's any potential ambiguity or loophole, people will try to go there. That's just how things go often in this arena.
I mean, this
we
whole
will,
issue came up because of a loophole. I mean, because someone found a loophole.
Right. And so I think to some extent the fact that the Ethics Commission can adopt regulations gives us some ability to address loopholes as they come up. But, I mean, you raise a fair point. I guess the only downside is that if we don't define support at all, there will be essentially zero guidance as to what support means until and if the Commission adopts regulations.
So, okay, if we had to have support, I would define it as support shall mean any public actions or statements encouraging or urging the election of an identifiable person.
Okay.
Right, I mean, with the other.
Yeah.
I think that's broader, and I think, and of course, I will concede that I'm hoping that my hypothetical is ridiculous and that it would be interpreted in the way that we all think it should be. If we're going to do this, I want to make sure we're as clear as we can be.
And I know who I'm thinking of, and the first thing this person is going to say is, we are not supporting the election of this person. We are supporting this person's thinking that he or she should run. You just built them their loophole.
Mm-hmm.
Yeah.
Okay.
I was actually thinking election seems to make it more restrictive rather than, yeah, that was my reaction when you said that.
Okay.
Because the big problem we had last time was the committees kept saying, we are not a campaign. We don't have a candidate. We can't be a campaign without a candidate. And the commission accepted that. But at the same time, they were raising money and spending money that had the effect of a campaign while not being regulated.
Could we solve it by having both in the definition, the one that's here and the one Commissioner Herb suggested?
Mm-hmm.
I wouldn't have a problem with that.
In the sense that there are two holes in the dike and we need to plug both of them.
Okay. My other comment on decision point 1 was, do we want to limit it to public support, or is that too narrow?
What provision are you looking at?
So I'm looking at A1, draft committee shall mean any person, group of persons, or entity that either receives contributions of $1,000 or more or makes expenditures of $1,000 or more in order to publicly support the election.
Do you mean take the word public out of 2? The definition of support?
A suggestion. I guess that would be redundant.
I think there's some merit in thinking about taking the word public out of the definition of support. Because why would we allow people to take private action, spend money on private actions, encouraging someone to run without reporting that?
Mm-hmm.
Oh, and that's it. We don't want to be in the business of determining whether the conversation or the expenditure from such an entity took place in a living room or a conference room of
Run for
some
office and I'll give you
organization.
this $50,000.
So, Mr. St. Croix, you think it would meet the goals more effectively if it were? I guess I'm not sure why it matters where it is.
No, I don't think it matters.
Do we need public? Is it too
Well, if it were just a prohibition on support, that would, I'm thinking aloud here, that would be going too far because anybody can say to somebody else, I think you'd make a great mayor, I hope you'll run. What makes it acceptable, if it's acceptable, is that it's the transfer of money behind that speech that allows us to get involved. Does that sound, as I say it out loud, does it sound plausible? So number 2 doesn't stand alone as a prohibition. It's the formation of a committee to do this, and and you could have a committee if it had no money. If the 5 of us got together and had a conversation with somebody totally independent of our commissioner roles, and no money changed hands, that's also okay. I'm just sort of kicking the tires on the
I appreciate that.
It wouldn't stop friends of someone who they think would be a good
Right.
candidate from taking him or her out to a nice dinner and saying, here are all the reasons for you to run. We're not capturing that kind of activity.
So, okay, so we're not intending to capture, I mean, what if it's a really nice dinner and it's,
And they got contributions from others toward this committee.
Then we want to know.
then we want to know about
Then
that.
the public wants to know.
And is that a public action?
No, I don't think so.
Right. But it would fall under a draft committee. That would be a draft committee that organizes.
It just wouldn't support,
Right.
publicly support a candidate, essentially.
Well, I think once you start collecting contributions, it's a public action. So if you are at this private dinner and you start collecting contributions for a run at an elective office, I think it's a public action. Or I think it translates into that. Because state law says that once you raise $1,000 or more, you effectively become a committee.
And
Well-
committees have to function in public.
Well, I do feel like the way this reads right now, that if I collected $1,000 from 5 friends, which I was told to use to try to convince somebody to run for elective office, and I spent that money by taking them out to entertaining them for an evening, that this would not be covered by, that would not be covered by this. I don't know whether we're intending to know about that kind of activity or not, but I don't think it would be covered by this.
No, I don't think it should be, because in that situation, you're not spending money to convince the voters.
True.
So I think maybe leaving the word public is okay.
Okay. Okay. Any other comments from the commissioners on decision point 1? public comment?
David Pilpel, I'm trying to kind of work through this language, including the top of page 2, lines 1 through 4. Sorry, it's giving me a headache. I would suggest a few points. On line 17 and 18, I would reword it slightly to say, in order to support the qualification of an identifiable person for city elective office, period. Because that presumes that that person has not yet qualified and that the purpose of the endeavor is to have them be a qualified candidate. It's not to support the election of that person, because if it's the election of whatever, or you could say qualification and or election, that would cover both. But it's really more about getting them to be a qualified candidate, and I'm actually thinking less about the draft someone over the summer and more the draft someone as a write-in, which actually happened in 1999 in the Amiano for Mayor campaign. And I don't know how contributions related to that were captured or any of, I mean, I recall some of that, but I'm trying not to recall all of it right this second. But the point is, you could have these same efforts that happened with Run Ed Run and Progress for All happen in the context of a write-in campaign, and I'm not sure if under this definition that would get captured. And I think the intent is to capture all that. So that's why I'm hung up on the qualification versus election. I think
Can I ask you a question about that?
Sure.
It's not clear to me why that's materially different from what we have.
Well, again, it's not necessarily the election of a person. That's not necessarily the goal of the committee, or the committee would assert that that's not their goal. It's to get them to run. And in fact, you might have a committee whose goal is to get someone on the ballot, not to get them elected, but to get them on the ballot to drain votes away from someone else so as to help someone else's chances of getting elected, that the whole thing is a big trick. You know, we're all operating in good faith in this room, but there are others outside this room that may not be, who may or may not be watching this on TV.
What was the language you were?
To support the qualification and or election, I think that's how it would say, of an identifiable person for city elective office, period.
I think that makes it more parallel to number 2 as well.
I was going to say,
Yeah.
but instead of the word qualification, I would use candidacy.
I'm not sure if candidacy encompasses a write-in candidate as well as not,
Forget what I said.
Okay.
But I don't like terminating the end of that sentence.
Just, you're saying you would include the who is not yet qualified.
Yeah. Mm.
Okay. I mean, presumably someone who has qualified is already covered by being a candidate. And I guess that was the other point that I wanted to make more globally here. The problem here is the state law definition of candidate. And we can add this section in local law, which is fine, and whatever version ends up tonight or thereafter will work for the moment, but I think we should urge the state legislature to change the definition of candidate to include an appointed office holder, because that was the root of this whole business to begin with, that an elected office holder is deemed to be a candidate.
That we definitely can't do tonight.
No, it's not on the count, but it's something that we could contemplate in the future, and I suspect that there'd be support for that. I suspect that there are other instances throughout the state.
Do you have other comments about what we can do?
Yes,
here
sorry.
now?
Thank you for bringing me back. I agree that the language in lines 19 and 20 are somewhat problematic. I don't know that they work into lines 16 through 18. I think they really only apply in subsection B. I mean, it's difficult to read 16 through 18 and import 19 and 20 into that, the in order to support language. It just gets a little circular. But I do agree that support should include actions or statements, whether public or non-public, that are trying to urge or encourage a particular outcome. I think that's the point of support. And I'm also trying to think through, if you've got a committee under state law, you've got a primarily formed committee that's a particular, yeah, I know, all right. That this is creating a new animal only under city law, but is requiring that animal to file reports that it wouldn't, yeah, all right, I'll just keep thinking about it. I think we're all trying to get this right.
Yeah.
I'm sorry, the last point on line 24, I think if we haven't figured out what the definitions are completely, we should try to get that right. I think it's dangerous to have a definition here that's complicated and interconnected and then say, oh, but the commission may further adopt regs to clarify this. I think we really should get it right and not rely on having to go back later and define by reg, where we already have a definition that's intended to be comprehensive.
Because we so seldom try to do things right the first time.
Well, we try, and we should. Look, I'm being supportive here. I'll shut up for a while. Thanks.
I think Commissioner Studley is correct. I think the addition of the words qualification and election will fix that concern and make it more parallel. Decision point 2.
Okay, so.
On line 18.
So we're going to say, in order to support the qualification or election of an identifiable person, the city elective office who is not qualified as a candidate.
Yes.
And are we going to add that parallel language to support as well, or
no?
Okay, we don't think we need that. I think that's probably right. At that point, it becomes redundant. I'm okay with that.
Could somebody just explain why? I thought that the change to number 2 was your thought about write-ins. That sometimes the pathway through might be not to encourage or urge a person to declare as a candidate, but that a well-funded write-in effort would not be a committee or a campaign because there was not a candidate.
Are you addressing this me?
Yeah. Well, I just thought I was trying to fix that particular hypothetical.
Right, and I think that the qualification and/or election
takes care of that.
Okay. And I don't know that it matters whether you put it in line 16 through 18 or 19 through 20. You probably don't need it in both. I mean, I wonder whether you need the definition of support at all if you've added qualification to line 16 through 18, but I don't feel strongly about it. Mr. St. Croix, do you have? I mean, I think Mr. Pilpel's point that if you read in what we've defined as support into, and replace support with our definition, it starts to sound fairly redundant.
Well, if I might, I think where I'm having the most trouble now is, and we're into subsection B for a second, on line 7, that you can have a circumstance where a primarily formed committee perhaps is only filing semi-annual reports and not pre-election reports, but in the instance where that primarily formed committee supports a candidate and using that language support then goes to the definition here. So I think you're trying to get, in that instance, a primarily formed committee to file additional reports that they might not otherwise file. And I think that's useful, important.
The reason I think leaving support in isn't redundant is I can't anticipate everything that someone will say in a draft candidate committee, but they're going to try to self-define if they want to try to get around this provision.
Right.
And so I want them, if they say, we're not raising money to elect him or her, we're just raising money to encourage them, that's covered. If we say we're not supporting their election, we're only supporting their candidacy, it might be absurd, but we've had absurd claims before. You know, I don't want them to try to self-define their way out of these requirements.
Mm-hmm.
Don't you view your definition of support as being all-inclusive?
Yeah.
I mean, that's why I tend to agree with the idea that we shouldn't eliminate the definition of support if we believe that language is all-inclusive, and it seems to me it is.
I'm fine with leaving support as is, provided we have the amendment that we've just been talking about in line 18, that it's to support the qualification or election of an identifiable person. Does anybody have any objection to that? Is there a motion to adopt decision point 1 as amended? Second?
Can you just clarify, what would lines 19 and 20 read? Just as written? Exactly as written?
As written.
David?
All in favor?
Aye.
Opposed? Okay, that passes. Decision point 2. Any comments from the commissioners? Public comment?
I'm sorry, we were just having a fun little sidebar over there. I guess the problem on page 2, lines 1 through 7, is that there aren't sufficient, what's the word? Commas.
Sufficient what?
Commas.
Okay.
Punctuation. So to try to figure out, to read that and try to interpret it, and, you know, we all try to do statutory construction here, but there are others outside that will look at it some other way.
Can you just tell me where you'd want to put commas?
Although I hate it, maybe in this case, the passive voice might be better, so it's campaign finance-related filings, reports, or statements shall be filed by either a draft committee or I mean, it's hard to read what that means for a primarily formed committee supporting a candidate seeking the city elective office for which the draft committee is supporting an identifiable person. I really like what we're doing here. I'm just having trouble figuring out what that means. Is it that they're filing for a candidate? Is it they're filing for the committee? I'm sorry. I'm having trouble with that language.
That's the problem with existing law. There's no candidate, therefore there's no campaign, and we have to identify what that is because the entities don't exist in current law.
Well,
Sorry.
If I may, is the intent to say that draft committees are subject to the same filing requirements as primarily formed committees? Is that the intent?
Yeah.
I was going to suggest language like that.
I like that.
Draft committee. Does it need to say draft committees that are supporting an identifiable person?
No, because that's the definition of a draft committee. Oh, Sasha.
Well, it is here, but it's in this section. Anyway, I think Commissioner Liu's suggestion makes sense. Draft committees shall file the same campaign finance-related filings, report, or statements as for or as required of, it's required to be filed by a primarily formed committee.
Right.
Can I just suggest that we use the same language that we have, but on line 3, stop it after city elective office?
Mm-hmm.
I like it. Can someone read it again as proposed?
Draft committees shall find, draft committees shall file any campaign-related filings, reports, or statements required by either state or local law for a primarily formed committee supporting a candidate seeking the city elective office. Or seeking city elective office, I think would be sufficient. Take out the. No, seeking city elective office.
I thought we had the word the same.
The same.
In there.
Shall file the same campaign finance-related filings, reports, or statements required by either state or local law.
That would be fine.
Yeah, that'd be the same.
Those 3 changes, excuse me.
So draft committee shall file the same campaign finance-related filings, reports, or statements required by either state or local law for a primarily formed committee supporting a candidate seeking city elective office.
I like that.
Okay.
We want it to be in the same cycle.
Mr. Shen?
Excuse me?
I mean, I think one concern is that you want to make sure you're addressing primarily formed committees in the same election cycle. So actually, I would suggest saying draft committees, all in the spirit of shortening things, draft committees shall file any campaign finance-related filings, reports, or statements required by either state or local law for a primarily formed committee supporting a candidate seeking the same city elective office. And just stop it there. So actually, the only change would be inserting the word same in the third line and stopping it after city elective office.
I don't know how that supports the cycle argument.
It does, because you've got election-related filings as opposed to semi-annual filings for general purpose or primarily formed committees. You can have a primarily formed committee that doesn't have to file pre-election statements because the candidate that they're supporting isn't on the ballot that cycle.
Right.
So, yeah, I get it now.
Okay.
So basically, we want any draft committee that's operating to support a candidate for, say, the mayor's office to file in the same manner as any other primarily formed committees that's actually in operation for a declared candidate for the mayor's office. Now, it's possible, although I honestly don't know how often this happens, that you could have a primarily formed committee laying around from an election that happened last year. Maybe that one doesn't need to file anything this year because it's not supporting a candidate in that November's election, say.
I think we'll address that in the regs. I don't think we need to worry about that here.
Right, but again, I think my impression is that people wanted to shorten up the subsection 1, which seems fine.
True.
And I guess my only suggestion is that we just insert the word same.
I have no objection to that.
I mean,
so you would add.
Because I think that's essentially what the last, 10 or so words of subsection 1 was trying to capture, that it should be for the same office.
I think that's fine. But, anybody have an objection to that? Okay. Mr. Shane, can I ask you, did you have any concerns about our definition of draft committee and support?
Yeah, not to necessarily reopen the issue at all. I think Mr. Pilbell's concern was that merely that subsection 2 wasn't parallel to subsection 1 anymore, and that subsection 1 refers to qualification or election. In subsection 2, if we just leave it alone, only refers to declaration as a candidate, and those are kind of potentially distinct actions or things. But I don't feel a certain, I don't have a strong feeling that we need to revisit that.
Okay.
But,
I don't either.
That's to the commission's discretion.
Do the commissioners have any other questions or concerns with respect to decision point 2? Is there a motion to adopt decision point 2 as amended?
How is it amended? What's the language?
It's what Mr. Shen just read. It'll read, draft committees shall file campaign finance-related filings, reports, or statements required by either state or local law for a primarily formed committee supporting a candidate seeking the same elective office. Is there a motion to approve decision point 2 as amended? Is there a second?
Second.
All in favor?
Aye.
Aye.
Opposed? Okay, that passes.
Can I just suggest one minor clarification? If you don't want to do it, I can understand on line 6, where it says, for city elective office, comma, the committee shall continue to file. Might you insert draft, so it says the draft committee, so that it's very specific that it's referring to the draft committee?
I think it's clear.
All right.
I mean, we use it 6 words previous.
Okay. All right. I
Don't need a
tried.
draft committee anymore.
Thanks.
Okay. I will make the offer for a short break once again. Commissioners, are we okay to go forward, or do you want a few minutes? Okay. Let's carry on. The next item on the agenda is the performance evaluation for Director St. Croix. Can public comment on matters pertaining to agenda item 5?
I support the good work that the director is doing, and I hope that you will find similarly in closed session. I do think it's worth having periodic or annual performance evaluations, including setting goals and reviewing the performance of your employee and ensuring that his goals and yours are aligned and progressing. Thanks.
The Commission typically discusses the evaluation of the Executive Director in closed session. Is there a motion to hold the meeting in closed session under Government Code Section 54957B and Sunshine Ordinance 67.10B?
So moved.
Second. All in favor?
Aye.
Opposed? Hearing none. We will deliberate regarding the performance of the Executive Director in closed session.
SF Gov TV, San Francisco Government Television. SF TV, San Francisco Government Television. CASA Gov TV. San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF Gov TV. San Francisco Government Television.
Okay, we're back in open session. Discussion and vote pursuant to Sunshine Ordinance Section 67.12A on whether to disclose any portion of the closed session discussed regarding the Executive Director's performance evaluation. Is there a motion not to disclose the Ethics Commission's closed session deliberations regarding the performance evaluation of Mr. St. Croix?
Second.
Public comment? No public comment. All in favor?
Aye.
Aye. Opposed? There's none, so the motion passes. Before we move on to the next agenda item, I do want to commend the Executive Director for his excellent performance this year. We had some trying issues come up, and I think we had some real breakthroughs as well in terms of some legislation and work we've been really trying to get done. And I think it's a testament to his leadership, and I think we've all benefited from his great work and the great work of the staff that works with him. We know that you all have a lot to do, and you do it extremely well, and you were asked to do things this year that I'm sure you did not expect to have to do when the year began. And to a person, we are very grateful. He wouldn't be nearly as good as he is without you, and we know that you guys are doing all the work, so really the credit goes to you guys. But thank you very much, and please express our appreciation to the rest of the staff. The next item on the agenda, discussion and possible action on minutes of the Commission's regular meeting of October 22nd, 2012. Any comments from the Commissioners on the minutes? Public comment?
David Pilpel. I think there are 4 points on the minutes somewhere in here. I think it should indicate that Ms. Herrick participated by phone, and I didn't find that. Maybe somewhere at the bottom of page 2 would be a good place. Up to you. On page 5, in bold, the motion moved, seconded, and passed, second line. This was actually pretty funny. Find that Mr. St. Croix and Ms. Lediju Croix. I wasn't aware, but hey, you may want to amend. And then in the following line, willful failure to comply with the Sunshine Ordinance Task Force. I think that's actually just a willful failure to comply with the Sunshine Ordinance. Let's strike Task Force there. And finally, on page 6, in bold, the motion that the Ethics Commission strike 2. So it would read that the Ethics Commission adopt the annual report as amended.
Sorry, where you, on page 6 where?
That the Ethics Commission adopt, take out the word. Is that correct?
Yeah. And I won't be submitting a 125-word statement, so it need not. Never mind. Thank you.
I think it bears noting that we've accommodated these folks after all this time, even though we don't have to, and none of them are here to see. Although I'm sure they'll see the minutes.
Is there I think Mr. Pilpel's changes are good, unless Mr. St. Croix, there's something we need to know. Any other changes to the draft minutes? Did you guys catch those? Is there a motion to adopt the minutes as amended?
So moved.
Second?
Second.
All in favor? Aye.
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 That's a question. Seeing I was not present, should I abstain?
You can't.
Pardon me?
You can't.
Not an option.
Have to vote.
All right. All right, I'll vote in favor.
Okay. The next item on the agenda is the Executive Director's Report.
Just one highlight this month, please. Again, bringing up the report that was done by the Board of Supervisors Budget Analyst comparing the San Francisco and Los Angeles Commission procedures. In order to bring that to a commission as a discussable item, we decided not to just show you the report, but to gather some public comment on, what the report actually means, so that we have some feedback to give you in advance of this. So we've scheduled 2 interested persons meetings in December, on the 4th and the 10th. To do this, you're welcome to come, as you are to all interested persons meetings, but if you do, you need to let me know in advance so we don't get too many commissioners at a non-meeting. And then we'll bring this to the commission in the new year as an agenda item. That's my only highlight of the ED report.
Thank you. Public comment?
David Pilpel, one of my favorite topics continues to be the list of bad people. I really would love for the new year if we could put together the list of all of the individuals who owe fees, fines, forms, other things starting with F, to the commission and why, and periodically update that and work to get people off that list. I know I've said this many, many times before the commission. It would just be great if we could do that at some point. And the goal, of course, is not to shame or publicize, but to get people off that list. We really would prefer that people comply. And I think not compiling that and publicizing it means that people feel like they can just get away with stuff. And if they write out the statute of limitations long enough, there won't be any penalty. So,
how long is that list?
Non-filers?
None of us, I don't think we know. I mean, there are different people who would be on that list from different sources.
You're talking about combining 3 or 4 different lists.
Correct. Yeah.
I think that's worth putting on our list of things to consider doing it. If it's feasible, we could put it on the website somewhere.
And maybe I can just conclude my last comment for the evening, hopefully. Is the commission intending to meet in December, or is that meeting going to get canceled?
Going to get canceled.
Excellent. Happy holidays to everyone. Thanks.
Holidays to you.
Next item on the agenda is discussion of items for future meetings. Hearing none, is there a adjourn the meeting?
So moved.
Second.
Do we need public comment? Is that what you're saying, Garrett?
But
Is there any more public comment? No public comment.
he said he wasn't going to make any more.
Okay. Meeting, all in favor?
Aye.
Opposed? None.
Better to be safe than sorry.
Meeting is adjourned.